How will the Supreme Court's multiple rulings be applied here in Oklahoma? The fact is, it's probably too soon to tell, but in our weekly in-depth conversation this week, moderator Susan Cadeau is joined by a panel of legal experts who are keeping a close eye on how these controversial new decisions will impact Oklahomans.
Yes, and I want to jump right in because there's so much to cover, and I never have enough time. I'd like to introduce our guests to you. We have Professor Jeremy Tillman, who is a professor with the Oklahoma City University School of Law. And then we have Brenda Golden, who is with Golden Legal Services, an attorney there. And I'd like to thank both of you for being with us.
Thanks for having me.
Thank you so much. It's an honor to be here.
Well, we're honored to have you both, and you're going to have to explain to me in layman's terms what's going on, because so much has happened at the federal level, legally speaking, with the Supreme Court. And Professor Tillman, I want to start with the case in New York, the New York State Rifle and Pistol Association v. Bruen. First of all, educate our viewers and myself, what is the crux of that case?
So that's a Second Amendment case, a right to bear arms case. New York and 5 other states had are so-called shall issue states. That is to say, if you want to carry a gun outside of the home, you need to apply for a license. And there are some criteria that you have to meet, but even if you meet all those criteria, the state still has discretion to say, but you don't really need a gun. And the court held 6-3 that discretion, that power of the state to say, no, you don't really need a gun to people, violates the Second Amendment. So that will affect those 6 states. The other are 5 states and the District of Columbia. The rest of the states have more permissive regulatory regimes, which, as far as we know, are constitutionally okay.
Well, Ms. Golden, I want to ask you, can states make their own laws?
Some states that have passed laws restricting the amount of bullets and that a person can purchase, so that they can't put the automatic chamber into the chambers. Some states have done that with it. Correct me if I'm wrong, Mr. Tillman or Professor Tillman. Those have passed muster.
Right. So I think there's some tension between the court's abortion decision, Dobbs, and the court's gun decision, Bruen, in that in Dobbs, the court is saying there's no role for the Constitution here. Let states regulate abortion however they want. And there's really no constitutional barriers on federal constitutional barriers on what the states can do. But in guns, they're going the other way and saying, no, the Constitution does speak to arms regulation. And there are lots of situations where this court at least says the federal Constitution prohibits gun regulation.
All right, I want to switch gears here and talk about what's commonly known as the McGirt decision, but it's officially known as Oklahoma v. Castro Huerta. Ms. Golden, tell us a little bit about that case first.
Well, the case involved a non-Indian perpetrator that committed child abuse against the Cherokee child in the boundaries of the Cherokee Reservation, which was Tulsa, Oklahoma. After the McGirt ruling, 43% of the state was deemed reservation because Congress had never de-established those reservations, which defaulted the crimes committed on Indian reservations under federal authority. So Castro v. Huerta challenged the long settled precedent that the federal government prosecuted crimes committed by a non-Indian on reservation land. And this has been settled law since the 1800s, basically, that the federal government only has the jurisdiction to prosecute crimes on Indian reservations. Now, this court has basically undone all of the precedent of 100 years, as well as eroded tribal sovereignty, because in the opinion written by Justice Kavanaugh, he states that the decision of Worcester versus Georgia, which established our tribal sovereignty, is wrong. and that states have authority over Indians within their boundaries. So I see it as a erosion of tribal sovereignty. And yes, the state is counting this as a win because now they have the authority to prosecute non-Indian offenders on reservations where they didn't before.
Do they have total rights in that to prosecute? Do the states have total access to do that now?
They have access concurrently with the federal government. Now, that means that both the either or could pick up the charges, which in the past has been an issue because some of the crimes that are committed on what we call allotments or trust land, restricted land, those have been hard to prosecute because you never know where the boundaries are at. And now the state has concurrent jurisdiction and we don't have to worry about those boundaries.
I was going to ask you, do the tribes have their own court system and they're sovereign nations? Why wouldn't the tribes prosecute or carry out prosecution or due process for any crime, no matter who committed it on their sovereign land?
That would make sense, except that Congress has limited the tribe's power over, as I said, hundreds of years. The Indian Civil Rights Act and the Tribal Law and Order Act limited the tribe's ability to hand down sentences longer than 3 years in prison. And then, of course, the Supreme Court in McBratney had limited the Supreme Court in Reno versus Duro as well, that tribes can't be trusted, in other words, to be fair to non-Indians. So we couldn't prosecute non-Indians for crimes committed on our lands.
So my last question, and this may not be the brightest question, but I don't know the answer, so I'm going to ask it. What is the difference between having federal prosecution versus state prosecuting crimes?
Well, of course, the federal guidelines and statutes for crimes are different than the state statutes and crimes. The whole process of prosecuting someone in the federal system differs from that in the criminal state system. So that there's a little bit of difference in sentencing guidelines and the type of crimes that the federal government.
I didn't know if there was a reason why the tribal nations preferred the federal prosecution to state level prosecution. So, and that's probably the reason then.
Well, the reason that it is because the boundaries of our sovereignty under the previous rulings had stated that any crime committed within our jurisdiction of our tribe the state could not prosecute in any way. And now that has been opened up.
All right. We're going to switch gears again. I think everyone has probably heard of the Dobbs v. Jackson Women's Health Organization, which basically overturned Roe v. Wade and has caused not ripples, huge waves across America. So I kind of want to talk to you, Professor Tellman. After that ruling was overturned, Supreme Court Justice Clarence Thomas said they should consider looking at same-sex marriage and contraception. What would have to happen for the Supreme Court to even look at those? And why would that be said? Why would that be tied to Roe v. Wade?
Right. So Roe v. Wade was based on a doctrine called substantive due process, from which we derive a right to privacy. The right to contraception and protections for homosexual acts and for same-sex marriage were also protected under the right to privacy derived from substantive due process. So Justice Thomas doesn't like substantive due process unless it has to do with the Second Amendment. And so he thinks now that we've gotten rid of substantive due process with respect to abortion, maybe we should revisit these other rulings that protect the unenumerated right to privacy. The thing is, though, he wrote for himself. The other 5 justices who were comfortable overruling Roe v. Wade and Casey pretty much specifically said they didn't think the ruling, that they said abortion was different, and they weren't interested, for at least for now, in challenging those other rights protected under the right to privacy.
Ms. Golden, do you think anything like that could happen?
I think that based on all of the legal precedents that this court has ignored in numerous rulings that have come out recently, that I would not be surprised, because they're overturning hundreds of years of precedent, and it seems like anything is fair game.
Can I just add two quick points? One is contraception is already under attack, perhaps accidentally, because there are states that are defining abortion as anything that terminates a pregnancy, and pregnancy begins at conception. But a lot of common forms of contraception prevent implantation of an embryo, and that would be, under these definitions, abortion. So under these strict definitions of abortion, some forms of contraception are now being called into question.
Such as which forms?
The ordinary pill, one of the things it does, I mean, it prevents ovulation, but it also thins out the uterine lining so as to prevent implantation. That would interfere. That would prevent a pregnancy after fertilization. And the other point I wanted to make is that, and maybe this segues to the other cases you want to talk about, I don't think the court is going to go after same-sex marriage directly, but it is whittling away at protections for LGBTQ plus people through the free exercise clause, which relates to religion. So this court is fine with allowing religious exemptions from any neutral law of general applicability, including laws that protect against discrimination based on LGBTQ.
And that does take us to our next case, Ms. Golden. I want to examine Kennedy v. Bremerton, a school district, and Carson v. Macon. Again, everyone is familiar with the prayer on the field ruling. How much do these cases impact the separation of church and state, in your opinion?
Well, I think between that one and the one where now the tax dollars can go to a religious school, kind of opens the wall of separation of church and state, because the prayer on the field concept is limiting the freedom of speech. Also is double. He goes to the 50-yard line and prays publicly. If that were, I'm sorry, a Muslim or some other religion, how well received would that have been? So we're impeding his freedom of speech by not allowing him to pray on field. That was the ruling in essence. And nobody that wants to see a different type of prayer, we're probably going to have a lot more, I hope, people coming to the center 50-yard line and doing that. But I think this opens the door. It's, of course, that wall of separation of church and state has been whittled away, chipped at, and it's this freedom of speech has opened up a lot more than what probably was intended in allowing that.
Professor Tellman, do you think folks might make a point by going to the 50-yard line and praying? Does it allow fairness for students to pray from other religions at school events?
So I do think that a lot of people are now going to be motivated to push the barriers and to see how far they can go in terms of public prayer at public schools. A lot of the difference between the majority and the dissent in the Kennedy case, the case of the coach, is really a dispute about the facts. The majority describes this as private prayer, but Justice Sotomayor in her dissent included an image of the coach surrounded by students at the 50-yard line, wearing his school uniform and holding up the football helmet of the team, all of which, you know, in older case law would have clearly identified that prayer as a public act by a public figure, and would have called into question the Establishment Clause, which prohibits government endorsements of religion.
All right. I have so many more questions I'd like to ask, but that's our time. I hope to have both of you back to address more. A lot of big decisions that came down today, a lot for everyone to sift through, especially in the legal field. Thank you both for your time and insight.
Thanks for having me.
Thank you for having me, Lana.